Hello and welcome to The View from Mayer Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It's presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. The time spent listening to these podcasts can count towards your continuing education requirements. And at the end of the podcast, we will explain how to get in touch if you wish to claim credit for continuing education purposes or if you have any comments or questions.
Hello and welcome to podcast number 169. The government over the weekend provided some updated guidance on the furlough scheme, and with, again, all due apologies to the person who contacted me saying how nice it was to hear a podcast about something other than the furlough scheme, I think this is sufficiently important to warrant a further podcast. I do promise we'll get back to normal life one day. I've got a couple of cases that I want to do podcasts on, but for now, I think let's just focus on the furlough scheme. So, as I say, on 4th of April, the government's provided an update to the previous guidance on the furlough scheme. This guidance note provides some helpful clarification in some areas. It definitely alters the scope of the scheme in other areas, but leaves some problems entirely unaddressed. This is hardly surprising, I think. I mean, if you think about it, these times are unprecedented in modern Britain, so it's hardly surprising that the original note, which was all of 7 pages long, is now 10 pages long with a commensurate increase in detail provided. But obviously one of the things I think we need to be quite careful about, and I'm quite sure I'm going to fall prey to it on this podcast too, is analysing the guidance note as if it was a piece of legislation, trying to divine the legislative intent in the guidance note. I think in some cases things are unclear. In some cases they may not have thought of things. And as we'll see in at least one area, I think they're choosing not to say anything. So let's look at the new points first. Well, first of all, an employer who wishes to claim under the furlough scheme for a grant now needs to be enrolled for PAYE online. And the guidance note says that can take up to 10 days to process, which is obviously important if you've got a payroll run coming up. And it would hardly be surprising if lots of people are trying to sign up right now, and as a result, that is going to produce greater delays, and therefore greater delays in getting paid. Next up, we know apprentices can be furloughed. The guidance note is clear that people can continue to train during furlough without breaking the terms of the furlough arrangement, and obviously they'll need to be paid statutory national minimum wage under the applicable legislation for the period of furlough. There is in fact a specific guidance note that's been produced subsequently on apprenticeships, and so if anyone does have apprenticeships, I'd encourage them to read that note too. The type of individuals that can be put on the furlough scheme has also been expanded. Company directors can be furloughed. This is a decision to be taken by the board of the company, formally adopted as a resolution of the board, according to the guidance notes. It's got to be put into the company records and communicated in writing to the relevant director. One key point to note is, whilst on furlough, it is permissible for the director to carry out such duties to fulfil statutory obligations that they owe to that company. But they should only do so to the extent that it would be reasonably judged necessary for that purpose. So this would not permit work generating commercial revenue or providing services on behalf of the company. Obviously, this is a bit of a grey area. So, for example, you've got an HR director on the board. Can they oversee and participate in the management of a redundancy exercise that the company decided was necessary to ensure continued solvency? For most of our clients, we anticipate that there will be non-furloughed resources available to cover a furloughed director's work, but there may be some tricky examples. But the most striking thing is that the note recognises that in some cases a furloughed director may be undertaking duties without thereby taking themselves outside the ambit of the furlough scheme. Salaried members of an LLP can also be put on furlough if they are designated as employees for tax purposes. Although the guidance note doesn't say this explicitly, we assume it's not possible to change the status of salaried members after the 28th of February 2020 in order to designate them as employees. The furloughing salaried members of LLP might, according to the guidance note, require a variation of the LLP deed. The reference salary for the purpose of the furlough scheme is the member's profit allocation, but that expressly excludes any portion of the salary which is related to individual performance or performance of the LLP itself. So this may, if you think about it, make the furlough scheme less attractive in the case of salaried members, because if the scheme covers 80% of the base salary only, and the base salary might be only 80% of the sums regularly received by the salaried member in the first place, it's proportionally less valuable. The biggest extension, though, is to include what are generally referred to as Limb B workers as category of individuals who can be furloughed. I think this is a realistic acceptance of their status, but it's helpful that the guidance note expressly recognises this. A Limb B worker, obviously, is someone who's not an employee, but who performs a role that involves them providing personal services to the notional employer, and the individual is not providing their services via their own business. Provided such workers are paid through PAYE, then they qualify under the scheme if their employer puts them on furlough. Otherwise, of course, they may be eligible for support under the scheme for self-employed individuals, and that's a separate scheme. There's a note about that on the Mayer Brown website for anyone who wants to look for it. Guidance note provides some clarity around the type of activities that can be done whilst on furlough. It's clear that volunteering work is permitted, provided it doesn't generate revenue or provide services for the employer. It's also clear employees can take on a paid job working for another employer if their contract of employment with the original employer does not prohibit that. Presumably the same would apply to setting up your own business in this period to try and generate some personal income. That wouldn't take you outside the furlough scheme. Might put you in breach of contract, of course, but it wouldn't take you outside the ambit of the furlough scheme. And obviously, staff who go to work for another employer after the 28th of February can't then be furloughed again from that new job. There's further clarity on which employees you can claim for as well. Unsurprisingly, the guidance note confirms that foreign nationals can be put on furlough if the employer wishes to do so. And as if it hardly needs reminding, prudent employers will bear in mind that the laws on discrimination are going to apply to decisions about who to furlough and who not to furlough. So obviously, in the unlikely event that someone was furloughing employees because they were foreign nationals, that would be unlawful direct discrimination. Employees who start working for an employer after the 28th of February can be rehired and then put on furlough. This is a really odd concept, and I've actually had some misunderstanding about this, where people thinking it's people who stopped working before the 28th of February. I have a couple of conversations recently. That's obviously one of my alarms going off. Anyway, the idea that you can hire people back after they have ceased working for you is a pretty surprising concept, and well, I'm a bit sceptical about whether employers are going to take this step, given that they will potentially lay themselves open to top-up costs, benefits, and then have to go through the process of ending the contract again when the furlough grant scheme comes to an end. The note doesn't say so expressly, but we assume that individuals would have to be rehired at their original salary, maybe unless the individual agrees to take a reduced salary. And very, very oddly, and point to emphasise, this ability to rehire is not limited to staff you have made redundant. It covers staff who have, quote, stopped working for you, unquote, which couldn't be wider. So resignations, retirement, performance dismissals, they're all within scope. Now, this might offer a creative solution to the TUPE conundrum, which we'll come on to in a moment. Government note also emphasises that staff who are working but are on reduced hours cannot be covered by the furlough scheme. Staff who are receiving statutory sick pay, whether because they're actually sick or self-isolating in line with medical advice, also can't be furloughed. However, employees who are unable to work because their childcare responsibilities preclude them working can be put on furlough. Again, an employer is going to need to tread carefully if the furlough is being imposed on an unwilling employee, in case this is discriminatory, but we assume the more likely scenario is the employee is going to be asked to be furloughed because of their inability to work. Employees on fixed-term contracts can be furloughed. Indeed, if their contract is due to expire, the employer can choose to renew or extend the contract, and that does not take the employee outside the scope of the furlough scheme. The guidance note has a new section now on agreeing to furlough employees. This provides that an employer should look to agree any changes to the contracts of employment with staff, but we don't think this means that employers who impose unilateral change or who drive through a contractual change, relying on a variation clause, for example, are outside the scope of the furlough scheme. It's simply a recognition that changes should be agreed where possible. It doesn't mean that there are no alternatives open to an employer. The note also confirms that the decision to furlough must be confirmed in writing to the employee, and the record of that communication needs to be kept for 5 years. There's some welcome clarity on what an employer can claim for under the grant scheme. The employer is entitled to include in the claim any, quote, regular payments that you are obliged to pay your employees, unquote. We think this means that most types of monetary payments to the employee can now be included. Examples given in the guidance note itself, well, that includes wages, past overtime, fees, and compulsory commission. I think there's some uncertainty about whether past overtime means overtime payments that were due for previous periods of working, or you can run a calculation based on what people have previously earned by way of overtime. Discretionary bonuses, tips and commission payments are not covered, and this represents a change from the original guidance, which excluded commission and fees altogether. There's no guidance on how regular a payment has to be included, or whether a fluctuating allowance can be paid as an average calculated against the 2019-2020 year. We've been asked by an employer if they could agree a standard flat rate allowance so that staff shared equally in the allowance paid. That might fit, but it doesn't seem to fit easily with the guidance note. I think a lot will depend on the terms of the contract and whether the employer has the choice as to how it approaches this, or whether it is fixed in the contract. Guidance note makes clear that the grant paid in respect of an employee must be paid in full to the employee for their gross pay. We assume that where the grant has not come through before salary is due to the employer will be entitled to recoup that against a salary payment. The employer must not, however, according to the note, deduct any money from the grant, e.g. fees for processing the payment. We think this provides an answer to the concern that an employer could reduce a salary after 28th February 2020, the date for assessing the relevant salary level for the grant, and if it was reduced by more than 20%, then in theory the employer could still claim 80% of the original salary and the employer could pocket the difference. This was never what was intended, of course, but it's now clear that the employer cannot pocket any part of the grant paid for the benefit of the employee. There are still some uncertainties created by the revised guidance note. The major concern is the extent to which the furlough scheme is only for employees who would otherwise have been made redundant. It must be recognised that when the total guidance to employers is 10 pages long, there's a lot of detail that's not in the note. But we think, despite a comment to the contrary in the note, we think furlough is not only for employees who would otherwise have been made redundant, although there needs to be redundancy contemplated before an employee can be put on furlough. The argument in favour of saying that there has to be an underlying redundancy situation and you're only entitled to furlough staff who would otherwise be made redundant arises from some of the language used in one particular passage. The clearest evidence in favour of arguing there has to be a link comes from the statement about whether or not employees who are shielding but who are not themselves sick or self-isolating can be put on furlough. The note says, quote, "You can claim for furloughed employees who are shielding in line with public health guidance if they are unable to work from home and you would otherwise have to make them redundant," unquote. This is a clear enough statement in relation to shielding, you might think, but the question is whether this link exists generally. The statement is odd, generally, as it implies if someone could work from home, you can't furlough them, and we don't think that's precisely what's meant, for reasons which we'll explain. A little bit of a detour coming up, so bear with me. Our view is that it's still the case there needs to have been no redundancy contemplated or envisaged, or it doesn't need to be thought that if staff are not furloughed they will have to be made redundant. There's no suggestion anywhere in the guidance note, for example, that when choosing people for furlough, employers should be using the sort of selection criteria that have been in existence for 40 plus years as part of a fair dismissal process. If furlough were to be the alternative to redundancy, so furlough was like the interim stage, you might have expected to see something along those lines. Secondly, there's evidence elsewhere in the note that is inconsistent with the idea there has to be an underlying redundancy situation. The purpose of the scheme is now stated in the note to be for employers whose operations have been severely affected by the coronavirus. The note provides, quote, "It is designed to help employers whose operations have been severely affected by the coronavirus to retain their employees and protect the UK economy. However, all employers are eligible to claim under the scheme, and the government recognises different businesses will face different impacts from coronavirus." This seems to recognise that adverse impact is the test rather than a need to make redundancies. If you can hire back employees who left you after 28th February 2020, which may include those who've left for reasons other than redundancy, how is that consistent with there having to be an underlying need to make redundancy? you are able to furlough staff on the basis that they cannot work because of caring responsibilities. That has nothing to do with redundancy, but the note says you can do it. And presumably when the virus passes and business reopens, and many people will be able to go back to work in an ordinary fashion because their prior caring arrangements will come back online again. Guidance note acknowledges that where the scheme ends, the employers may have to consider termination of employment for redundancy. That's sadly true, but there's no suggestion if the employer does not make the employees redundant at that point, then this may cast doubt on the grant that may by then have been paid to the employer for the employee's benefit. We think the explanation for the odd statement around shielding is this. It relates to a very narrow set of circumstances, i.e., where the only reason for considering furlough is that the individual is shielding, i.e., there's plenty of work to go around, they could work from home, then they can be put on furlough if they would otherwise be made redundant. If there's not enough work to go around, so furloughing is necessary, then they're being furloughed because of a wider issue and not because they are shielding. There's then a related issue. The guidance note does not say that employers can be furloughed ahead of a redundancy or during redundancy consultation. So although the purpose of the scheme is to enable staff retention, employees facing redundancy or at risk of redundancy are not excluded from the possibility of being furloughed. But that leads on to a further question. Can such staff participate in redundancy consultation exercise without breaking the terms of the furlough and so take themselves outside the scope of the scheme? Can an employee representative attend collective consultation meetings to engage in collective consultation on behalf of their constituents if that representative is furloughed? We've seen this as an issue with paid union representatives who may need to undertake duties on behalf of their members. We understand that at least one large union is taking the view that carrying on such duties is not for the employer's benefit, so it's not a breach of the furlough scheme. The same logic would apply to redundancy consultation, we think, as the beneficiary of the work being done by the employee during the consultation exercise is primarily the employee themselves. We certainly think this is the sensible view to take, and we hope that that's the one HMRC will take too. Can an employee take holiday on furlough? What about public holidays? Can an employer make an employee take holiday whilst on furlough and then use the grant to claim back that, in effect, holiday pay? Well, there's lots and lots of debate on this, and some fantastic and learned articles. So I step into this area with some trepidation, but we think the short answer: there's nothing in the note itself about holiday and holiday pay, and given that employment lawyers and commentators have been pushing for this to be clarified as a matter of urgency, especially with Easter coming up, we think the omission is rather telling. Assuming it's a deliberate failure to address the situation, we consider that the government accepts that holiday may be taken whilst on furlough, but does not want to say so explicitly for fear of a wave of employers trying to require employees to take their holiday during furlough, which we imagine might arouse some controversy. Under English law, it's clear that an employer can generally require some holiday to be taken at a time specified by the employer. If the government does not preclude this possibility in the new guidance note, it presumably does not view that as precluding the possibility of a grant being paid in respect of an employee on holiday. There may be all sorts of employee relations nuances to consider if the employer makes people take holiday, as there would be if the employer prevented people taking holiday they'd already booked. But we think the silence in the guidance note points towards the answer the normal rules apply. This viewpoint is strengthened further by an ACAS advice note to employers and employees on coronavirus, which came out on 3rd April, which has a specific section on holidays during furlough. This seems to make it clear that in the view of ACAS, an employee on furlough can request and take holiday in the usual way, which also includes taking bank holidays. There's nothing in the ACAS note to suggest that by doing so they forfeit the ability for the employer to receive a grant in respect to that period. The ACAS note also states that employers should still be encouraging workers and employees to take their paid holiday, and employers, it notes, have the right to require staff to take holiday at a time specified by the employer. Now, it's a fair comment to make that there is at least one very good article out there online which takes issue with the idea that employers can require employees to take holiday, and therefore that step might be more controversial. But certainly as a basic principle, we think it is now clearer that employees who want to take holiday and the existence of public holidays when, say, a factory is closed in any event will not take people outside the scope of the furlough scheme. Further issue relates to the rate of pay for any holiday leave taken during the period of furlough. Again, little guidance, but we think the position will probably be clearer in practice than in theory. If employees are being furloughed without any pay reduction, then, of course, in general terms, the holiday will be calculated in line with the generally applicable European and British legislative obligations. There may be some issues around particular allowances which have been affected by the furlough leave, but if the employer is treating such staff as being on variable pay, then presumably they'll either be paid at an average rate across 2019-20 or a comparison of the same month in 2019. We think that obviously the issue of allowances is going to be one that employers are just going to have to think a little bit carefully about. But if staff have been furloughed with a pay cut, then we think the position can be made clear when the furlough letter is being drawn up. Since it is open to an employer and employee to agree a pay cut, which applies for all purposes when calculating benefits, there's nothing to stop staff agreeing that the pay cut applies to their holiday pay for holiday when on furlough. However, where staff have been furloughed without that clarity, then we think a tribunal, faced with a claim for underpayment of wages, would probably take the view that the full rate of pay was payable. They may well be tempted by the argument that if the employer wanted to cut holiday pay too at the same time, it should have made this clear. Bearing in mind that it was uncertain up until the weekend whether staff could take holiday on furlough, this I think is probably a great example of hindsight being a wonderful thing. Again, I should make clear there is at least one very respectable, eminent indeed view online, and an opinion I've seen that says holiday pay has to be paid at the full rate, even if staff have taken a pay cut. So if anyone is pushing this through, I think it's important to look online, see if there's been any more recent guidance since this podcast. But it's clearly a difficult and controversial area. One other issue which has come up for advice a few times for us to look at is whether or not staff who have agreed to be furloughed with a pay cut can then be excluded from a redundancy exercise. Or, to turn it the other way around, can your redundancy pool be limited to those who've declined to take a voluntary pay cut? Well, assuming a fair procedure has been followed and due consultation carried out, we think that in general terms, a proposed redundancy pool consisting of staff who declined a pay cut and to be furloughed is potentially fair. The question for the tribunal is whether the approach adopted in any redundancy exercise is within the band of reasonable responses. So an employer has, considerable liberty when identifying the pool. In Tamek and Ryan, the EAT said, quote, "The question of how the pool should be defined is primarily a matter for the employer to determine. It would be difficult for the employee to challenge it where the employer has genuinely applied his mind to the problem," unquote. The employer should make it clear, obviously, when asking about the pay cuts, that furlough coupled with a pay cut to save costs is a necessary step. The redundancies are very likely to follow if pay cuts are not agreed by sufficient numbers of employees. Then, individual staff will be making a decision knowing what the alternative course of action will be. In this situation, we think an employer would have a strong case that it was fair to restrict the pool for redundancy purposes to those who had declined the furlough and the pay cut. Clearly, there will be employee relations issues. Clearly, this may be very harsh on individual employees who are unable to accept a pay cut for entirely legitimate and good reasons. But since the focus is on whether or not the employer's choice of redundancy pool is one which a reasonable employer might have adopted, the primary focus will be on the employer's reasons for the pool rather than the individual employee's reasons for rejecting it. Finally, a number of commentators have flagged up that the TUPE transfers after 28th February risk taking staff who might have been eligible to be furloughed out of the scheme. This is clearly a loophole, but the argument is a sound, logical one. The effect of the TUPE transfer is to break employment. The guidance note does not say anything about this expressly, which again is interesting, and it could surely have done so if it wanted to clarify the position. But we think there is a potential workaround. If employees could have been furloughed by the old employer, and the transfer is after 28th February 2020, we know from the guidance note that an employer can take back staff who have ceased to work for it. Remember that they can have ceased to work for the employer for any reason whatsoever. If the new employer wants to furlough the staff, then it agrees with staff that their contracts with that employer are suspended. The old employer hires them back by consent, furloughs the staff, and then, when the furlough scheme is finished, more alarms going off, when the furlough scheme is finished, the employee's temporary arrangement with their old employer ends and the underlying contracts with the new employer become operational. Indeed, there would seem to be some potential for an employee to work some percentage of their time for the old employer and get hired by the employer to be furloughed for the balance of their time. Anyway, we know that a furloughed employee is able to work for a third party without being in breach of the furlough arrangements. In short, with some explanation and a degree of creativity and cooperation. We think a transferor and transferee who wish to ensure that a TUPE deal goes ahead, where the transferee needs to be able to furlough some staff, should be able to achieve this. Would have been simpler if the guidance note confirmed that TUPE transfer was not viewed as being new employment post 28th February, but there we are. Right, well, there we have it. Thank you very much indeed for listening. Hope that was useful, and no doubt there will be more updates and developments as this goes through. But yes, it would be nice to get back to doing some ordinary law, wouldn't it? Anyway, everyone, hope you stay safe, take care, and until the next of these podcasts, I will wish you a happy day. Take care.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.